Reid. I am Bill Reid, legally William, but call me Bill. And we are talking today about tenancy issues. I just wanted to mention that they are just one of the kind of things that I can help TMAPS students with. I'm available for legal advice and assistance regarding any legal matter. Whatever I can do through the TMAPS office is a free service. And so I do help a lot of students with housing situations, but also family law and employment and other civil matters, criminal charges, provincial offenses, government matters, including but not only immigration, and also starting businesses. Not all negative things. Some students are looking to start businesses either while they're students or after they finish, and we can talk about that kind of thing as well. So today, yes, we are talking about housing, and most self-contained apartments in Ontario are governed by the Ontario Residential Tenancies Act. And the Act establishes the Landlord and Tenant Board, which administers the Act. Now, there are situations to which the Act does not apply, and most commonly that is if you live with the landlord and the landlord shares the washroom or the kitchen or both. And so again, the Residential Tenancies Act governs most rental housing, but typically the kind of conventional self-contained unit where one or more people rent from the landlord, but the landlord doesn't live there. Sometimes a landlord may live in the same building, even in a house, but if there is a self-contained unit with its own washroom and kitchen, and usually entrance, well then again the act applies. You're not really living with the landlord. You have a self-contained unit in the same house. You're not living with the landlord. So, all of those situations are governed by the Act and the Landlord and Tenant Board. If you actually do share the washroom or the kitchen or both, then it's a little bit different situation, not necessarily a bad situation. It's just important to be aware of the fact that the Act and the Board do not apply. So it is especially important in those situations to have, well, it's important in all situations to have a good tenancy agreement, and just maybe a little bit different depending upon the relationship with the landlord. And we can move on to the next slide. It is certainly important to view a rental unit under any circumstances before making a commitment to rent or making any payment. If a landlord makes any promises, absolutely, it's important to remember that they won't be enforceable unless they turn up in the ultimate written tenancy agreement. Sometimes a landlord will say, oh, you can park outside, there's parking, or there's free Wi-Fi, or there's this or that. All the utilities are included. You can use the backyard. I've heard of all kinds of things that tenants have been told. And then if those things don't end up in the written lease, they are of no legal effect, and very often a landlord will renege on those things, and the tenant doesn't get to have those things after all, even regardless of what the landlord said. So it is important that any promises the landlord makes end up in the written lease, or they won't be of any legal effect. And then check the ultimate lease before signing it to make sure. Don't again take the landlord's word for it. Review the lease. Don't feel rushed to sign it. Take your time to read it. Make sure everything that you think you agreed to is in it. If a landlord doesn't allow you to view the premises, and sometimes there can be what sound like credible reasons, oh, it's being cleaned or it's being repaired, but this one's just like it. Well, don't assume that those things are true. Maybe they are, maybe they aren't. Always try to view the actual unit that you are going to be renting and living in. And if the landlord has some reason why you can't see anything, well, all the more so. That's a red flag. If the landlord asks you to sign anything or make any payment before you get to make your own decision as to whether you want to rent, those are likewise likely warning signs you shouldn't proceed. And we can move on to the next slide. So a landlord does have the right to request written information about a tenant's income and rental history, because a landlord has the right to ensure that someone who's renting has the reasonable ability to pay the actual rent. So the landlord does have the right to ask for that, to ask for information about the tenant's income, and to request a guarantor if the tenant's own income is not sufficient to reasonably pay the rent. A landlord also has the right to ask and to know within reason where the prospective tenant has lived in the past, and maybe they've never rented before, and that's fine to say if that's the case, as long as, again, there is an income stream and some indication whether the person has lived with family or whatever to indicate that, because a landlord does have the right to reject a prospective tenant who can't reasonably afford to pay the rent, or in the past has failed to pay rent or broken other rules when renting from other landlords. A landlord also has the right to view and just keep a copy of a prospective tenant's government identification, but not to require a social insurance number. And a tenant must then remember, as I said, don't feel pressured to make an agreement, don't feel pressured to sign or pay anything until you make your decision. But if you make a decision that you're going to rent a certain place, and then you sign and make a deposit, as you then should, well, you've made a legal commitment and don't expect to be allowed to back out. Once a tenant has made that decision and taken those steps, it's not perceived to be fair to a landlord for the tenant to just say, oh, I changed my mind. So don't expect to do that, because once things are signed and a payment is made, there is a legal contract, and the tenant is bound as much as the landlord is. And we can move on. I've talked before about reviewing the tenancy agreement, the lease, and Ontario does now have a standard form of lease for tenancies governed by the Residential Tenancies Act. And the thing is that in the past, before 2018, which is when the Ontario government first implemented the standard form of lease, before that, I saw a lot of leases that landlords had drafted, and of course, some landlords didn't care about tenants' rights or tried to impose on tenants' rights, but some landlords tried to be good landlords, and they tried to write proper leases, and they still didn't know enough about the law to really write a lease that was fair to the tenant. So this is why the Ontario government did implement a standard form of lease, and all tenancies governed by the Residential Tenancies Act, it's supposed to be used by the landlords in all those situations. If a tenancy is the kind that is governed by the Act, a self-contained unit, and the landlord does not give a standard form of lease, either gives a different form of lease or none at all or whatever, a tenant has the right to make a written request for a standard form of lease, even in place of a written lease that's already been signed, and possibly to terminate the tenancy if the landlord doesn't provide the standard form within a reasonable time. And all of this is set out in the Residential Tenancies Act. I mentioned before that, of course, there are situations, especially where one lives with the landlord and shares facilities, that are not governed by the Act. And many of the situations in their standard form should then also be included in a lease to which the Act does not apply. Not all of them, but many of the same things. And so it's, as I said, it's important both ways. It's important likewise if someone is living and sharing with the landlord, still important to have a written tenancy agreement that contains all the essential points, including anything that they feel the landlord has promised them. And we can move on. So, because many of the rules that govern tenants govern everyone, for example, noise bylaws, um, and also because the Residential Tenancies Act prohibits certain rules, certain things that landlords are not allowed to make rules about, the rules that a landlord may make are actually quite limited. So again, the city has bylaws about things like noise and about things that can be put up in a yard or hung out of windows in certain cases. And these govern everyone. So landlords don't have to make rules where the city bylaws already say certain things. Even if the landlord lived in the premises themselves, they'd be subject to those bylaws. The Residential Tenancies Act does say that landlords may not make rules about certain things, and this is carried over into the standard form of lease as well, which says that certain things like rules against pets or rules against guests are not legally enforceable. So the rules that a landlord may actually make are quite limited, as I said, and a landlord may prohibit smoking even inside a unit. They may make rules about the use of common areas, such as laundry room hours, and they may require that a tenant have tenant's insurance. Now, all tenants should have tenant's insurance in any event. We'll come back to that later on. Certainly, everyone, all tenants who live in a self-contained unit governed by the Residential Tenancies Act absolutely should have their own tenant's insurance. It can be a little bit less absolute, less certain in situations where you actually share with the landlord. But in each of those situations would be different. It's an issue to look into in each of those situations. As I say, we'll come back to tenants insurance in a later slide. For now, we can move forward. As far as terminating a lease, a landlord is pretty limited. A landlord may terminate a lease as a result of default on the tenant's part, and default obviously would include not having the rent paid, but it may also include habitually paying late. So even if at a particular time the rent is paid up to date, if the landlord can show that, yeah, it's paid up for this month, but every single month the person pays, or even every second or third month on a repeated basis, they pay a few days late, that can also be cause for termination, cause that enables a landlord to terminate the lease, even if the tenant would rather go on living there. Also, default can include things like violating noise bylaws or just making enough noise within a house or within a building, a house or otherwise, that disturbs other tenants, doing other things that are dangerous or may break the law. Any of those kind of things, not always financial, are ways that a tenant may be in default of the lease, thereby giving the landlord the right to terminate it. Now, another reason why a landlord may terminate a tenancy is if the landlord himself or the landlord's immediate family intends to live in the unit. There's a form under the Residential Tenancies Act that the landlord must give to indicate when they or their family intends to occupy the unit. It prescribes how much notice has to be given, and in many cases requires that the landlord give the tenant a 3 months' rent. So there are disincentives, and still a landlord may only take that course of action if it is legitimate. If they or their family genuinely intend to live there, they can't just say that they're going to, so that the tenant moves out. That it actually has to be a situation where the landlord or a member of the landlord's immediate family genuinely intends to live there, and if a tenant moves out and finds out that didn't really happen, the neither the landlord nor any family member actually moved into the unit, there is a form that a tenant may file with the landlord and tenant board to say that the landlord gave me the notice in bad faith. And the tenant may then be entitled to moving fees, storage fees, possibly if they've had to pay a higher rent someplace else. So these are all mechanisms that are built into the system to try to ensure that landlords don't abuse their rights and that they do in fact exercise in this situation only if it is valid, only if it's true, and operating in good faith. Also, if the landlord intends to do major renovations, again, they may give a tenant notice, but likewise, there's a specific form. It has to state the date and give sufficient notice, and it can only be used if the landlord genuinely intends to make such significant renovations that that the tenant cannot reasonably live there while they're taking place. So you may have heard the term renovictions, and yes, it's true that landlords can evict tenants if they genuinely intend to make such major renovations that no one could possibly be living there while they're making them. They do have to give the tenant the first right to move back in when the renovations are done, but they have the right to, the landlord has the right to raise the rent, and the tenant in most cases will have signed a lease and started living someplace else. They won't want to move back. So the whole thing can be and is sometimes abused, but that's why I go back to saying that the renovations have to be so significant that a tenant can't reasonably be living there while they're taking place. And a tenant may dispute this if they receive the notice and they say, no, like, what's the landlord doing? I can live here while you're doing that. If it's rewiring, like electrical, or if it's plumbing, well, we can move my stuff. If it's painting, if it's flooring, well, we can move my things to one side of the room while you do whatever you're doing to the empty side, then move my stuff over to that side while you do the other side. So a tenant does have the right to challenge the notice, and it can go before the landlord and tenant board if necessary to make a decision as to whether the renovations are really so significant that the tenant can't reasonably live there while they're taking place. As I said, then, the rights that landlord has to terminate a lease are limited, and they can only be exercised in good faith, meaning that if the purpose for which they exist, that the opportunity, that the right to terminate exists, that the facts actually exist to support that in that situation. And we can move on to the next slide. So when can a tenant terminate? Well, a tenant may terminate at the end of a fixed term or the end of any subsequent rental period on 60 days notice. A lease in the standard form says that it can be for a fixed initial term, and very often kind of the most common standard initial term is 1 year, but the law doesn't say it has to be. The parties can agree on a fixed term that's shorter or longer than that. In any event, a tenant must then realize in signing a lease that they're making a commitment for at least the duration of that fixed term. tenants do hear sometimes that, oh, well, you can terminate a lease on 60 days notice, 2 months notice. Yes, that's true under certain circumstances, but not just all the time, not in the middle of a fixed term. If you sign a lease, for example, for November 1st, this coming Saturday, until next year, October 31st, you're making a commitment to live there for that full year. Don't decide in February or June or whatever, oh, you know what, I want to move out early. I can just give 2 months notice, because you can't. You can give 2 months notice that will be effective only upon the end of that fixed term. If a fixed term expires, the tenant does not have to move out or sign a new lease. The existing lease continues on a month-to-month basis, and at that time, the tenant may, at any time, give 60 days notice. As long as you don't sign another fixed term, once the fixed term is up, it's month to month. You can move out anytime on 2 months notice. But the notice must be effective at the end of a rental period. For example, if you pay rent on the first of the month, then the notice can only be effective on the last day of a month, not any other day. And likewise, whatever day of the month, sometimes people do sign to pay on the 15th or whatever. Well, likewise, in that situation, notice would have to be effective as of the 14th. So in any case, any time when the lease indicates, as it always would, what day rent has to be paid every month, a notice of termination may be given effective the day before. The most common situation being rent paid on the 1st, notice effective the last day of the previous month. So again, 2 months notice effective the last day of a rental period. Now, the only other ways that a tenant may terminate a lease, one of them is by order of the landlord and tenant board or city inspectors. As I said, you sign a lease, for example, for a year. You can't just move out earlier just because you decide to. If there is a problem with the premises that the landlord has not rectified, or with the landlord's behavior, if you have evidence of them persisting in harassing behavior, in situations like that, you can apply to the landlord and tenant board for an order for early termination. The landlord and tenant board does have the right to say what a tenant does not have, which is, even though this lease goes until October 31st, it's hereby terminated on May 31st. Like I say, a tenant can't just do that. The landlord and tenant board can, if they're satisfied that grounds exist. For example, severe maintenance issues that are not rectified, or severe harassment by a landlord. In a greater number of cases, the landlord and tenant board would order a partial rent reduction, and perhaps retroactive, but would not necessarily order early termination. There are lots of little maintenance issues or other problems that justify a partial rent reduction, but don't really justify early termination. So, yeah, you can apply for early termination, or call in city inspectors, because they also, and I've helped students living in certain places where they moved in, they thought it was fine, they were paying rent, but then little problems arose, and city inspectors came out and find, well, it doesn't satisfy building codes. The ceiling is too low. There's no fan or window in the washroom. There are not sufficient fire escapes or other fire-related, like smoke alarms. And in any of those situations, the city inspectors or the fire department may make an order saying that a landlord has to fix certain things by a certain date, failing which the tenancy is terminated. Or they may just say it's beyond remedy. I mentioned like low ceilings, for example. and it's just not a habitable unit, and the tenancy has to be terminated within 30 days or something like that. And that overrides a lease where there are building or fire code issues that make a unit uninhabitable. In the absence of those grounds, a tenant who wants to move out really would have to find someone to replace them. Students sometimes feel that if they drop out of school, if they lose a job, if a family member is sick and they need to go home and look after them, that they then have to terminate their lease. Well, maybe so, but those situations are not perceived to be the landlord's fault or therefore the landlord's problem. A tenant losing a job or dropping out of school or having a sick family member, those things are not grounds that give the tenant the right to terminate without any further liability to the landlord. As I mentioned, the situations that do give the tenant that kind of right is if there's an actual problem with the unit that the landlord is not rectifying, or a problem with the landlord's behavior, because those things are the landlord's responsibility. But personal situations like jobs, school, sick relatives are not the landlord's problem, not the landlord's fault, therefore not the landlord's responsibility. So if a tenant wants to move out for any of those reasons or any other reason that they may have, unfortunately, it's the tenant's responsibility to find someone to replace them, either as a subtenant under a sublease, which means that the tenant remains the principal tenant and they may come back and move back in at a future point. Either that or an assignment under which the tenant actually assigns the lease to a different new tenant who steps in and now lives there. The tenant would have to obtain the landlord's consent to either a sublease or an assignment, but the landlord does not have the right to unreasonably withhold consent. And we can move on. I mentioned before about tenants having tenants insurance, and there are two main reasons for that. One is if there is a situation in which a tenant's personal property is damaged, destroyed, or stolen, a fire, a flood, a break-in. In such situations, a tenant may say, well, I'm sure the landlord has insurance, and the landlord will have insurance on the building and any of the landlord's own property there, but the landlord's insurance does not cover the tenant's personal property. Furniture, electronics, personal documents like passports or money or other clothing, food, any of those kind of things are not covered under a landlord's insurance policy. If there is a fire, a flood, a break-in, uh, those are things that a tenant's own insurance is intended to cover. So it's one of the reasons why a tenant should always have tenant's insurance, certainly in a conventional situation of renting a self-contained unit. The other reason to have is potentially even more significant, which is to cover liability resulting from the tenant's own negligence. If a fire is potentially caused by a tenant, and that can happen, you leave an element on the stove, you knock over a candle, a pet knocks over a candle. Again, pets are legal, but but you're responsible for their actions. Same with guests. A guest comes, landlord can't prohibit it, but if the guest knocks over a candle or otherwise starts a fire or does something, well, you can be responsible. That is where, again, your tenant's insurance ideally steps in to cover it, because, like I say, a fire, a flood, if you leave a tap dripping, or something that you should have noticed was dripping, even like under a sink, and you never checked, never noticed, never mentioned it to the landlord, the damage can be very costly to your own unit, but it can also extend beyond your own unit. And likewise, if you spill something, even in a common area, you accidentally spill something and someone falls on it. Now, these are all situations in which, as a tenant, you may potentially be seen as having caused damage and could be sued for it. And in the examples I give, we could be talking about tens of thousands of dollars. So this again is where where tenant's insurance comes in, and why a tenant should always have tenant's insurance to cover both the tenant's personal property and liability resulting from the tenant's own negligence. And we can move on. So, as Chloe said, I am easy to reach, and I have tried to make things fairly clear and complete. I am happy to answer a few questions, but as Chloe said, we don't want to get into personal situations, and there's no need to, because the email address that is shown there, I do try to be very quick to respond to, and we can have a complete discussion about a personal situation over email. And even as we speak, we could still do it later today into tomorrow. I'm very quick to respond. And in any situation in which it would be appropriate to meet virtually, we can do like we're doing now over, well, I mean, just student and myself have a Zoom, a Google Meet, or meet in person. Sometimes when I talk about other kinds of legal services I provide, notarizing documents, notarizing signatures, or making notarized photocopies of original documents are things that I would do in person, and we could arrange to do so in most cases, at the student center, like I say, in person, but otherwise we can meet virtually, and I do a whole lot of communicating back and forth with students over email through that email address, and any kind of any kind of conversation we have is completely confidential between me and the student. No one else sees it, and that is the beauty of corresponding that way. Having said that, I'll pass it back to Chloe.
Awesome. Thank you so much, Bill. That was super informative. And I don't know about anyone else. I have a couple of questions even, but I'll give the floor to everyone else. So if you do have a question you want to ask, feel free to put it in the chat. You can send it to an TMAPS support Chloe, and I'll read it aloud on your behalf. But I also, before folks leave, want to share some additional resources which may be helpful. So while you guys are chatting or putting your questions in the chat, I just want to talk a little bit about these three things. So there's ACTO, and these are for you to go through on your own time. But they're a non-for-profit that provide resources and information on how to deal with tenant or landlord issues. So this one thing to note is that it's Ontario specific. It's an Ontario specific resource. So if you're in another province, you'll have a different version of ACTO that you'll have to look up. We have the main website listed on top, and you would go to the for tenants section. But they have a great resource page, which is also linked there above. And basically, it centralizes a bunch of external databases, such as lists of libraries or catalogs, or just legal clinics in the province, which may be interesting information to peruse. There's also Steps to Justice, which is listed here, and it simply breaks down what you can expect when it comes to various legal processes, some of which Bill discussed today. And one thing to note about these is that these are just guidelines. They may not be specific to your situation, or they can be very jargon heavy. So I always recommend consulting with Bill, emailing Bill after going through some of these resources on your own. That's why he's here. He's here to help you navigate the system and support you through this. And then the final one is Renovictions TO. So it basically highlights some of the buildings that are flagged as having gone through or currently undergoing renovictions, which could be helpful. And another reason why this is included is that, if something's happening to you, there's a chance that someone else is going through it as well, so it's an opportunity to connect with others who may be in a similar situation to you, and to organize alongside them. So I'll just leave these up on the screen for anybody who wants to take a picture of it, or they should be put in the chat for you as well. Now let me just look to see if we have any questions here. So I have one question, Bill. It says, what is a good service to get tenant insurance from? Can you speak to that a bit?
Yeah, many banks offer it. And if you do have accounts, one or more accounts with a Canadian bank, especially, in most cases, in my experience, another department of the bank offers tenants insurance. And it's usually like in the 30s, maybe $40 a month, something like that. Uh, and you can also just do a Google search, Ontario Tenants Insurance, and other places that provide it will come up. Not all insurance companies do, but many insurance companies, and like I say, some banks. And if you just do a Google search, you'll likely uh, find options. And I would say to speak to more than one and make sure that you do a little bit of like shopping around to make sure that you get the coverage you need and at a competitive price.
Hmm, thank you. I hope that answered your question. I have another one here. A single parent with under 19 child rents an apartment. Child is mentioned in the lease agreement. Child becomes an adult. What if something happens, such as sickness or death, or a parent moves out for other reasons? Will the adult child get evicted? Is that possible?
Well, in most cases where there are two or more tenants, the landlord approved the rent based upon the income of the two or more tenants. So even if we're talking only about adults and one moves out, there the remaining ones may have to go through a process to show the landlord that they can still afford the rent without the departing one. Uh, it's not just like automatic that um, one tenant moves out, like one roommate moves out, and a landlord has to be satisfied with the remaining. So, because there, like I said, there can be a reapproval process. If a minor is shown on a lease, I mean, a minor can't be held to a contract anyway, especially where like a parent has already signed it. I would think that if a a minor is shown as another occupant, I would recommend that they be put on the lease as a co-tenant once they're an adult. And that would do more to preserve the right to remain there if the parent moves out or passes away or anything. Um, and again, the the child, as I'll call, but now an adult child, would have to have the income sufficient to pay the rent, and the landlord would have the right to inquire into that. So it's not like an automatic situation where it's an automatic yes. It's a little bit of an unusual situation to have a minor child named on a lease to begin with, as an occupant is one thing, but not usually as a co-tenant. So I would say try to make them a co-tenant once they become an adult, and it will deal with some of these issues up front rather than when the adult seeks to move out, if that helps.
Okay, awesome. Thank you. I have a couple more here. Okay. Upon a lease renewal, by how much can landlords increase rent? And is it legal for the landlords to increase rent from, say, 2,200 to 3,000 over 2 years? The house was built in 2018 and I'm in Durham region.
Well, the one thing is that rent control doesn't apply. Like, well, I'll back up. There is rent control, and every year the Ontario government states the percentage by which rent may be increased on the anniversary of an ongoing lease. It continues month to month, uh, and it can only be increased theoretically one time whenever the lease renews, but not renews, but the anniversary date comes up within the calendar year. But rent control does not apply to premises that were first occupied on or after November 15th of 2018. So the problem is that a relatively newer premises like that is not rent controlled, and uh, the landlord may still only increase the rent once per year, but may do so in accordance with what the market will bear. And it can be more than the percentage that applies to the older units to which rent control applies. So again, it isn't really a matter of Durham region as opposed to any other, but if the unit was built in 2018 and first occupied uh, late that year, it probably isn't subject to rent control. That can be confirmed. There's a way to confirm whether it is, but it sounds like it isn't. And so the short answer is that yes, once per year, but without limit.
Okay, awesome. Thank you. And then the last question would be, what kind of documentation would be important to have to prove harassing behavior from a landlord?
Well, again, these things I talk about that might lead to a rent reduction or early termination are all matters of degree. When I talk about maintenance issues the landlord hasn't properly looked after, that's where the landlord and tenant board has the discretion to order a rent reduction of a percentage that they think is fair in the circumstances, every situation being different, or whether they or may decide to order early termination. Again, it's up to them. They try to be consistent in their decisions, but all situations are different. So, what does consistency look like? With harassment, well, evidence would include recordings or videos, witnesses, that was put into writing. Uh, all of those are really like the best kinds of evidence. And usually there's a context as well. Usually there's some kind of a conflict between a tenant and a landlord in which the harassment takes place. But so there may be more to prove or other things that it may justify, for example, termination or a rent reduction without having to totally prove the harassment. But the harassment itself, if that is the main thing or conceivably the only thing, like I say, witnesses to it, uh, recordings, videos, and you can record a conversation that you are a party to. It's not illegal. It's illegal to record conversations you're not a party to, like eavesdropping on people's conversations. But you can record a conversation you're a party to. You don't have to inform the landlord that you're doing so. There's no guarantee that the landlord and tenant board or any other court will accept it as evidence, but it is not against the law to do. So recordings, videos, witnesses, anything that they have put in writing that is harassing, um, those are the things that can potentially prove that harassment has occurred.
Fair enough. That sounds good. I'm not seeing any other questions at this time. So I'll switch to our final slide here. These are just some upcoming events that are happening that we would love to see you at. I can't tell you how grateful I am that you're here, Bill, that you did this, and I'm grateful for everybody who showed up. We're I just